So this is the one I like. This is a list of various investigative document procedures. You can use this as a training guide for your managers and supervisors. And don't underestimate the importance of training. Not only are you required to comply with the mandatory training by the state, but you want to make sure that your managers are trained in your own internal processes and that they know how to use and where to access your own forms. Uh, if it's possible, my recommendation is to go above and beyond, that minimum 1 hour, 2 hour mandatory training. Here, this slide covers documents that you're going to want to gather and review during the investigation. And Vanita went through quite thoroughly those types of documents that you'll need to gather in this whole process. The best practices is to review all these pertinent documents. Ask everyone that you interview, do you have any documents? Are you aware of any more documents? Can you take a look, in your desk and you see, did you take any notes? And don't overlook, your own internal files. That might have key information that is going to impact your investigation as well. Now, so you've conducted all the interviews, you've been summarizing your notes, you're making findings, and now it's time to prepare the summary report. The report is key because it's the culmination of everything that you've done to date. You'll need to summarize the facts, your findings, include opinions, come to conclusions. Always include your senior management team, the decision maker, and even legal counsel in finalizing that report. It, so some things coming to the report. What if you have inconsistent findings? Then you need to consider whether should I follow up with an interview with somebody. Are there other documents that I can look at that reconcile the inconsistency? Can I make a credibility assessment? Absolutely, you can. And in many instances, you'll be required to make a credibility assessment in order to reach some sort of conclusion and prepare that report. So in this slide, the EEOC has published some guidance on determining credibility. And that first one is implausible or inherent implausibility. Is the testimony believable? Does it make sense? What is the demeanor of the witness? Did the person seem to be telling the truth, or does the person seem to be lying? Is there a motive to falsify? Does that person have a reason to lie? And is there corroboration of what any of the witnesses said? Is it corroborated by eyewitnesses to the event or by physical evidence? And lastly, look at past records. Did the alleged wrongdoer have a similar behavior in the past? Continuing on here, the EEO guidelines for credibility say that no single factor is determinative as credibility. Again, take that holistic approach. Look at all the evidence and testimony that you've gathered throughout that. So some examples. So the fact that, there are no eyewitnesses to alleged sexual harassment, that doesn't necessarily mean that the claimant lacks credibility. After all, many acts of sexual harassment are happening behind closed doors. And the fact that an alleged harasser engaged in similar behavior in the past, be careful, because that doesn't necessarily mean that he or she did so again on this particular occasion. So some things to be mindful of when you are weighing credibility of witnesses. And the report. So the standard that's used for a report is it the preponderance of evidence standard. And that means, is it more likely than not that the alleged conduct in fact occurred. So you want to review and assess all your witness statements, the evidence you gathered, and make sure your factual findings and conclusions to make a determination. Does all of that mean the conduct that's alleged more than likely occurred? The report then is going to need to make recommendations for corrective actions. It's very important to include that. The recommendations must be fair and calculated to end the problematic conduct. And the type of corrective action is going to vary as much as there are all the varying types of alleged complaints to begin with. But some possible examples of corrective action might be requiring additional training or changing certain written policies in your handbooks, transferring someone, a demotion, a possible suspension without pay, or maybe even termination is warranted. So this is another handout. It's a list of all the key elements that you should use in your summary report, whether the investigation and complaint is small or large. If you do nothing else for your report, answer every one of those questions. If it's a small investigation, the summary report might be 1 page. If it's a very complex investigation with 10 plus witnesses, it's going to be a multi-page report, but include all of these details. This is a good framework. It can be adapted to almost every type of investigation that you're going to encounter. Moving to this next slide. Thanks, Pooja. So after making the credibility determinations, evaluating the facts, management must make the final decision about what to do. Be sure to inform all the involved parties of that determination. And even if the employer determines that harassment or discrimination did not take place, continue to take steps to monitor what's going on with the accused, what's going on with the complainant, continue preventative action, training, whatever is necessary to round out that circle of your investigation. And then let's move on to this next slide. Best practices. Again, keep up your diligence when the investigation is completed. Take the actions that necessary to ensure that the company is complying with its conclusions and findings in the report. Continue to assess what changes might be needed throughout the workforce, in your policies, anything that might happen. If we go to the next slide here, there is some resources. Both the California Civil Rights Division, formerly the DFEH, and the EEOC, both have published guidance on conducting workplace investigations. These are very helpful documents. I highly recommend that you take a look at those and keep those in your arsenal of resources for your HR investigative team. Let's move then, and then I'm going to briefly go over that. I think everybody does know that California has mandatory requirements for both supervisors and non-supervisors. The non-supervisors is 1 hour, and the supervisors are 2 hours. I've detailed some of the requirements here. I highly recommend that you set up a system to track all of these training. The bigger the workforce, the more you want to have a good handle on who has undergone the training or not. In a sexual harassment litigation, for example, one of the first things that the plaintiff's attorney is going to ask is, I want to see the certifications that this defendant underwent his training. If he doesn't have them, that's not a good piece of evidence for your case.